Hello again, and welcome back to another edition of the Wiccan Conservative. So, the first wave of January 6th trials has wrapped up, and staying true to fashion, I wanted to bring you the details of these cases. Now, there have only been 3 trials thus far. And I'm going to scroll all the way to the bottom of this AP article to give you a little bit of refreshing background information into what exactly we're talking about if you've been living under a rock for the past year. More than 780 people have been charged with riot-related federal crimes. The Justice Department says over 245 of them have been charged with assaulting or impeding law enforcement, and more than 250 riot defendants have already pled guilty to mostly non-violent misdemeanors. Of the remaining members who still need to go to court, 3 people are already done, tried, and in the books. Jurors have convicted 2 rioters of interfering with officers. One of them was Thomas Robertson, an off-duty police officer from Rocky Mount, Virginia, and the other was a Texas resident, Guy Reffitt, who was also convicted of storming the Capitol with a holstered gun. The third Capitol rioter to be convicted by a jury was Dustin Byron Thompson, an Ohio man who claimed he was following Trump's orders. So, of course, I want to get into detail about all 3 of these gentlemen, but I'm not going to do that on one long drawn-out video. Today, I want to focus on the Texas resident, Mr. Guy Reffitt. This in front of you now is the government's omnibus opposition to the defendant's post-trial motions. As we have already established, Guy has went through a trial already. He has been convicted by a jury of his peers. So he has now become guilty of 5 counts. 5 counts. Following this trial. None of the 3 post-trial motions filed by the defendant, in the opinion of the government, has any merit. So, just as a real quick background to this case, on March 8th, 2022, following over 3 days of evidence, the jury returned a verdict of guilty on all 5 counts. The court then orally denied the defendant's initial Rule 29 motion, on which it had reserved ruling, finding that the evidence was more than sufficient to sustain the jury's verdict on each count. The background of this is that during the trial, Guy had evidence used against him that he felt was not sufficient to sustain the jury's verdict. It was damning, obviously, because the jury did find him guilty, but he's challenging the legality of the evidence that has been submitted in court before him. Now, this is really important because a lot of these cases rely upon social media posts, video surveillance done by people in the crowd, news cameras, and body cam footage. So there's an array of video surveillance that is used, and there is also testimony in this particular case from the defendant's son and family members, which is not uncommon with any of the January 6th cases. A lot of people had their entire lives completely researched, history, background, friends, everything gone through with a fine-tooth comb until they could find somebody who would testify against these people in a court of law. So under the bold number 2 is the legal standard for the court. The legal standard, Rule 29, permits the defendant the move for judgment of acquittal at the close of the government's case in chief or at the close of all evidence on the ground that the evidence presented is insufficient to sustain a conviction. So that is 100% within his rights. He is allowed to challenge the evidence presented against him in a court of law. According to the government, the court must consider the evidence in the light most favorable to the government to determine if any rational trier of act could have found the essential elements of the crime beyond a reasonable doubt. Basically, what that means is you should be able to trust that the evidence submitted by the court is upstanding, that it is not manufactured, manipulated, clipped, or cut in an unfavorable circumstance to the defendant or in a way that would infringe upon the defendant's right. Stated otherwise, a judgment of acquittal is warranted only when there is no evidence upon which a reasonable mind might find guilt beyond a reasonable doubt. So when considering Rule 29, motion after a verdict, the court must view the evidence in the light most favorable to the verdict and must presume the jury has properly carried out its functions of evaluating the credibility of witnesses, finding the facts, and drawing justifiable inferences. Again, that means that they have already argued the piece of evidence as it was being submitted into the trial, that the defendant had the proper opportunity to dispute the evidence that was going into trial. So it's very, very hard to overturn a piece of evidence once it's submitted into the legal record. It's very hard to overturn this, especially when you're talking about credibility of witness testimony. Now, again, this is the jury relying upon the word of somebody else to determine what the intentions or actions of the defendant were beyond a reasonable doubt. This is all just about the credibility of witnesses, the credibility of the video, and the standards of the evidence. A defendant's Rule 29 burden at the post-verdict stage is very high, in part because evidence to support a conviction does not need to be overwhelming. No, it does not need to be overwhelming, but it needs to be beyond reproach. If you have even one reasonable scenario that can be played out, shown by circumstantial evidence, then you have to consider that reasonable outcome as well as the outcome proposed by the prosecutor. So if you have gone through the motions of a trial and now we are at the end stages of the trial, the post-verdict stage is very high for this burden. Very high because they've, again, already had the opportunity to argue this in a courtroom in front of the judge. Indeed, the court owes a tremendous difference to a jury verdict. The defendant cannot surmount that demanding standard here. Rule 33 permits the court to vacate the judgment and grant a new trial if the interest of justice so requires, which means if all of this evidence and reasonable doubt was put into record, and the jury did not regard a reasonable case scenario as being enough to warrant a non-guilty verdict, the defendant could ask the court to set aside the jury's verdict in the interest of justice, meaning that, yes, all the circumstantial evidence points to this, but there's no particularly hard evidence that shows beyond a reasonable doubt. Yes, the circumstantial evidence is overwhelming. That means you were in the right place at the right time and you had motive to do something, but they don't actually have you committing said crime. So, in order to grant a new trial, the evidence must preponderate heavily against the verdict such that it would be a miscarriage of justice to let the verdict stand. This power should be exercised with caution and is invoked in only those exceptional cases in which the evidence weighs heavily against the verdict. I would disagree with that particular statement in just the regards that I said. Usually the evidence is circumstantial, and that's what sways a jury. You have opportunity, means, and motive, and you don't actually have the smoking gun, so to speak. This case states that the evidence goes against all that, and a jury would convict anyway. That would be the United States versus Edmonds case. I'm not familiar with the case, but that is what the court's opinion was. In that case, this is an exceptional case in which the evidence weighs heavily against the verdict. That's all that means. The defendant bears this heavy burden under Rule 33 to meet, and he must show that there was a substantial error and the error affected the defendant's substantial rights. And that just goes back to the high burden of proof that now is on the defendant. So when you walk into a court of law facing charges from the state, your initial charges, you have the presumption of innocence until you are proven guilty. This is why it's so important that citizens themselves know their rights, and especially the right to remain silent when they are under arrest, because you are innocent until you are proven guilty. In a court of law, anything you say can and will be used against you. When you come out of a trial and you already have this verdict rendered against you, it's on your record. You are now guilty, and you have to prove beyond a reasonable doubt that you are not guilty, because 12 jurors of your peers decided that you were guilty. You went through the process, and this is what has happened. So finally, Rule 34 permits the defendant to move the court to arrest judgment if the court does not have jurisdiction over the charged offense. Again, we talked about this through the entirety of these cases. These protesters were coming from out of state into the District of Columbia, and they were asking for their trials to be moved back to their home jurisdictions, knowing the prejudice that would follow them in DC, and also the harder it would be for them to get back and forth from their hometowns to all these court hearings. And again, in very little cases were they able to remove the trial from the DC circuit to the home circuits. They actually are carrying out a majority of these trials, I believe, and to the best of my knowledge, in DC. So motions to arrest judgment are rarely granted. The only basis for a Rule 34 motion is that the court lacked jurisdiction over the offense in the first place, and in which case that would not be applicable because DC is in the direct jurisdiction of the DC Circuit Court. So a lot of these people really didn't have a shot at getting their cases removed back to their hometown. So then it goes into the argument and dismissing each count for acquittal. The government claims that the motion for judgment reads like his closing argument focusing on witness credibility, alleged inconsistencies, and innuendo about altered videos. I found this very interesting to read because that, in my opinion, is the full basis of whether or not they were making an argument in court about the witness's credibility, inconsistencies in witness testimony, and the potential to have altered videos put on the record. They made the same argument in closing arguments, and they're still arguing the same thing, which, again, knowing the prejudice that the DC constituency has or could potentially have against these protesters, I don't find it beyond the realm of suspicion to bring those things into play. Count 1, transporting a firearm in furtherance of a civil disorder. Count 1 charged the defendant with transporting a firearm in furtherance of a civil disorder in violation of 18 U.S. Code 231A2. To establish that offense, the government has two areas of burden. They have to prove that the defendant transported a firearm in commerce, and the defendant did so knowing, having reason to know, or intending that the firearm would be used unlawfully in a furtherance of a civil disorder. And that was the actual final instructions given to the jury. The government claims that there's sufficient evidence for a rational jury to find that the defendant transported two firearms from his home in Texas to Washington, D.C. Mr. Hardy testified that the defendant brought an AR rifle and a semi-automatic handgun in his cross-country trip. Mr. Hardy further testified that the defendant left his AR-15 rifle fully assembled in his car in the hotel garage in Georgetown on the morning of January 6th. That's really just only one prong that they had to prove. They had to prove that he transported a firearm in commerce. So in regards to the AR was transported in commerce, but did so knowing, having reason to know, or intending that the firearm would be used unlawfully in a furtherance of a civil disorder. So the AR was not used in the furtherance of the civil disorder. So that gun in particular, in my opinion, just reading this document right here, if somebody testified he saw it go from Texas to the Capitol, they've only hit one prong. Jackson Reffitt testified he saw his father bring the AR-15 and his handgun back into the house upon his return. That just furthers the first prong of the accusation, that the firearm did go from point A to point B. Second, the evidence easily supports the jury's finding that the defendant transported the firearms into the district having known or reason to know or intending that the firearm would be used unlawfully in furtherance of civil disorder. So here's where I break with the logic that you knew or you intended to know that the firearm would be used unlawfully in a furtherance of a civil disorder. I don't think unarmed will be the case this time. I will be in full battle rattle. If I break the law, so be it. This is from a Telegram message, and you have to consider a few reasonable doubts when it comes to Telegram or social media, in my personal opinion. When somebody is talking or chatting or texting online, personally, I don't believe everything that I read. It's really interesting to be aware that these things are hackable, but when it comes into a court of law, that's not seen as considerable, reasonable doubt, and that people's words are always taken for the worse. I don't think on arms will be the case this time. That's very suggestive and vague, if you ask me. I don't think. Nowhere does he say that he is going to explicitly carry this gun. I will be in full battle rattle. That's very open-ended and ambiguous as well, in my opinion. If I break a law, so be it. Well, I've said a lot of if I, should I, could I, would I, but does that necessarily mean that that was their intent? Is it your intent to break a law if you claim, if I break a law? That seems to me that you don't want to break the law, but if that's what you are going to do by being in a place or being on a location, that's very vague and ambiguous to me. It seems that if you had a more solid piece of evidence, that would be the time to bring this into the equation, not a telegram message in which the defendant says XYZ. Moreover, although guilt on count one does not depend on any civil disorder ever coming to pass, the evidence clearly established that the defendant was a full participant in a civil disorder at the Capitol. And I find this particular phrase to be the most damning of pretty much anything that I've read in accordance with this trial so far. Guilt on count one does not depend on any civil disorder ever coming to pass. We're now going to charge this man because he took his guns with him across state lines. Now, again, we can agree to disagree on what the civil disorder meant, how far you can go with your quote unquote civil disorder as far as being labeled a riot or a protest. But this says that you don't even have to have a riot or a protest. You just have to say that you were willing to participate in a civil disorder and claiming that you have the means to participate in a civil disorder. And if anybody hears you making those claims, they can be called to testify against you, stating that indeed, yes, even though nothing happened, you are still guilty on furthering civil disorder. So I'm a little bit confused on that entire interpretation, especially when you state that no disorder ever has to come to pass. So continuing down, it was a public disturbance involving acts of violence, in parentheses, there were many, by more than 3 people, in parentheses, there were hundreds, if not thousands, which, going back to the AP article earlier, what did they say? Like 780 people charged with riot, not thousands. So hundreds, correct, thousands, dramatic. I digress. Thus, the riot at the Capitol, as the court already found, constituted a civil disorder. So again, way to completely step on the first sentence of your paragraph there in saying that it doesn't really depend on any civil disorder coming to pass. But just so you know, a civil disorder came to pass. So why even bother wasting the ink to type that, other than to scare anybody who is reading these documents as we are now? B, count 2, obstruction of an official proceeding, a rational jury could have found, as it did, that the defendant violated 18 U.S. Code 1512C2. Here, the defendant does not seriously argue this point. Rather, he unsuccessfully attempts to re-litigate correctness of the court's instructions to the jury, stating that, there was sufficient evidence in play. These people have had this evidence, have had these videos for going on a year now. They have been redacted. They have been excluded from the public eye. So many different things could have been done with this evidence on the back end. Count 3, entering or remaining in a restricted building or grounds with a firearm. So this is where it got really good. Count 3 charged the defendant with entering or remaining in a restricted building or grounds with a firearm in violation of 18 U.S. Code 1752A1 and B1A. To prove the defendant's guilt on this count, the government was required to prove that 1, the defendant entered or remained in a restricted building or grounds without lawful authority, and 2, that the defendant knew the building and grounds were restricted and that he lacked the authority to enter or remain there, and 3, knowingly used or carried a firearm during and in relation to the offense. And I say it gets good here because we already know about the AR-15 that was left in the garage of the hotel when he brought it up from Texas. His buddy already testified to that. Indeed, the defendant's concession makes it clear that the first 2 elements are satisfied. So the first 2 elements were that he entered and remained in a restricted building without lawful authority, and he knew that those grounds were restricted and that the lawful authority was not bestowed to him to stay in that area. They claim that he makes that concession. When we get into whether or not he had the gun, it states that there is plentiful evidence supporting the third element, that the defendant carried his handgun with him when he went to the Capitol. Okay, well, what's the evidence? A firearm holster is visible on the defendant's hip while he is on the banister of the Capitol. A firearm holster, okay? Agent Hightower testimony about the holster visible still in the frames. Next sentence, the defendant told others before and after that he was carrying his firearm. Okay, again, just because he said it, does it mean that he did it? So what if he told others before and after that he was carrying his firearm? As far as I know, that's hearsay. And if you have a picture of the firearm holster, why can't you see the firearm? Jackson Reffitt testimony that Exhibit 214 between 626 and 754, the defendant explains he had a loaded firearm while at the Capitol, and defendant took the firearm out of the holster to display it to Jackson Reffitt. And this exhibit is the Zoom recording of the defendant telling William Tier, quote, I had my ellipses 40 on my side. Have you never bragged to your friends before? Have you never stretched the truth to make yourself look a little bit more badass or just a little bit cooler than what you really ended up doing? No, this guy neither. Count 4, obstructing officers during a civil disorder. In count 4, the defendant was charged with committing or attempting to commit an act to obstruct officers during a civil disorder in violation of 18 U.S. Code 231A3. To prove that offense, the government was required to prove that 1. The defendant knowingly committed an act or attempted to commit an act. 2. In doing so, the defendant intended to obstruct, impede, or interfere with law enforcement officers. 3. The law enforcement officers were at the time engaged in lawful performance of their official duties incident to and during a civil disorder. And 4. The civil disorder adversely affected either a federally protected function or commerce. These were the final jury instructions. The government could also meet its burden by proving that the defendant attempted to obstruct the officers. Well, that's kind of interesting because I'm pretty sure that you have 4 prongs to fit here. And even though you can prove, you do need to prove that the defendant attempted to obstruct the officers, you also have to prove the other 3 prongs as well. You don't get to just pick and choose which ones you want to cover. All 3 officers had to engage with the defendant with less than lethal weapons: pepper ball launcher, projectile launcher, and spray OC canister, and in an attempt to stop his advances. And the officer's attention being focused on the defendant allowed other members of the crowd to further penetrate inside the scaffolding, further endangering the officers. As the defendant's motion points out, Sergeant DeCamp testified that the defendant was incapacitated after he was hit with pepper spray. Sergeant Flood testified that the defendant sat down after being pepper sprayed. As an initial matter, it is not clear what, if any, legal significance attaches to this fact, given that the defendant had already engaged in his obstructive act at officers by that point. In any event, Sergeant Flood also made clear that he did not see the defendant after their interaction because he went inside the Capitol building to assist with the Senate. So they are stating that this man was waving and gesturing for the crowd to surge forward even after he was sitting on the banister. And the surveillance video showed the defendant walking up the stairs with the rest of the crowd around 2:15 towards the door of the Senate wing that were initially breached at 2:13. Showing the initial breach and showing the defendant walking up the stairs. If they had him on camera, why didn't they show him breaching the wing? Oh, no, that's right. They're not charging him with breaching the wing. They're charging him with inciting other people to breach the wing because he preoccupied the officers. Moreover, the defendant himself told his fellow Texas 3% militia members that he had made it to the landing outside the Capitol building before he finally turned back. Zoom recording in which the defendant states, "I got up the steps to where it was level. You could see the doors and they were beating on the doors. When they finally broke through, my job was done then." So again, we have a Zoom call, a Zoom recording, not actually his going in and breaking down those doors himself, just his civil disorder participation merit for distracting the police officers by being pepper sprayed and pepper balled and all this stuff, which again, remind me, did he have a gun on his hip? Because I think you told me that he had a gun on his hip. And if the officers were close enough to be threatened by this gentleman, and all of this chaos was ensuing, and they had to pepper spray him and they had to incapacitate him, why didn't they pick him up? Why didn't then he get arrested on this? How was he able to turn away and walk away from this? I'm confused. I'm trying to jump on the bandwagon, and I'm trying to get on the page of the jurors, but I really need to understand then how he was able to walk away from this with a gun on his hip and being so aggressive towards officers. Count 5 charged the defendant with obstructing justice by hindering communication to law enforcement through force or the threat of physical force in violation of 18 U.S. Code 1512 A2C. That crime has 4 elements. The defendant knowing, used, or attempted to use physical force or the threat of physical force against his children. The defendant intended to hinder, delay, or prevent his children from communicating information about an actual or potential crime to law enforcement. And 3, there was reasonable likelihood that at least one of the communications targeted by the defendant would have been made to a federal officer, and 4, the information that would have been communicated to the federal officer related to the possible commission of a federal offense. Final jury instructions. Those elements were amply supported at trial. So the government claims that, first, Jackson Reffitt testified that the defendant told him and his sister, "If you turn me in, you are a traitor. Traitors get shot." He took the statements as a threat. He was scared for himself and his sister. According to Jackson Reffitt's testimony, the defendant also said to Peyton Reffitt, "You better not be recording this, or I will put a bullet in your phone." He took the comments seriously and reported to the FBI later that day that his father threatened him and his little sister. From that testimony, a rational jury could easily conclude that both the defendant threatened his children with force and that the defendant, in issuing the threat, intended to prevent his children from communicating with law enforcement about the defendant's participation in the riot at the Capitol on January 6th. This is Guy Reffitt's son. I'm not exactly sure the age of the child. I'm not exactly sure of the atmosphere in the home, and I'm surely not in any position to call judgment to anybody. But where would a son get the impression that his father attending a protest at the Capitol was in commission of a crime? Where would he get that idea? Where would he get that sentiment to show up to an FBI agent? How does a young child come into contact with an FBI agent? I'm just asking a question. I find it very interesting that this child would be so knowledgeable to know that what his father did was a crime, to know that it was a federal crime, and to go to the levels that have happened in this instance, where this child is in a courtroom on the stand testifying against his father. Second, the defendant's words in the context in which he used the threats makes clear that his children, in particular Jackson Reffitt, envisioned communicating to a federal law officer about the defendant's potential or actual federal crimes. As the court found, a jury could credit Jackson Reffitt's testimony that Mr. Reffitt threatened to shoot his children or put a bullet through his daughter's phone if they informed the FBI about his actions on January 6th and the information they would have provided, and indeed Jackson had already provided, related to the federal offenses. A rational jury could therefore find that Mr. Reffitt obstructed justice by threatening physical force in violation of Title 18 United States Code Section 1512A2C, or that he took substantial step towards obstructing justice. I know that in context here, you're probably inclined again to agree with the jury, but let's take these claims and put them in a family court setting where a child is maybe determining where they want to live or determining whether or not they get removed from a household. Children's words are sometimes used carelessly, sometimes used in an exaggerated fashion. And the fact that we're relying on this child's testimony is concerning to me. That again, through all the video evidence, through all the substantial witnesses and officers and people who were literally there on the day of, you need to rely on third-party statements made prior to and after the incident, and what you've already decided has been your star witness is the child of the defendant to make your case. And this is the first trial that I have gotten into the back end of the court documents. But if this is a prelude of what's to come, buckle your seatbelts because it's about to get really fun. In conclusion, the court should deny the defendant's 3 post-trial motions according to the government. Your opinions will be many and ranging, I'm sure, but I highly encourage you, as always, go read the documents yourself. A lot of things are, again, free on courtlistener.com. You can also get the actual PACER documents from the pacer.gov website, and all the links will be available to you in the description box below. On that note, I will catch you guys on the next one.